I'm the Immigration Clinic Director. I'm a clinical professor at the University of Houston Law Center. I'm also here with Professor Michael Olivas, a nationally renowned expert in DACA and immigration and higher education law.
My book.
So what we're going to do today is talk a little bit about the contours of the decision that just came out, and then we'll open it up to questions.
I've got one.
There are two principal points that we can talk about up front. The first is the issue about judicial review and reviewability, which the Supreme Court came down very solidly in favor of the ability for the court to review DACA and the rescission of DACA. And then the second part, obviously, is on the APA, on whether or not the administration correctly followed the procedures in the APA, Administrative Procedure Act, and whether they gave a reasoned analysis or not. So I'll turn it over to Michael if you have any preliminary remarks, and then I'll say a bit, and then we can open it up for questions. Michael, do you want to have an opening statement?
Yes, thank you. This is proof that there is a God. This particular case resembles another recent Supreme Court case where the administration also tried to have it both ways, tried to shut down a program or institute a new program without going through the proper steps. This reasserts the rule of law and shows that a majority of the Supreme Court in a 5-4 decision, although there's a little bit of fudging because several people ascribe to parts of it, but it's one of two ways that the Supreme Court could have gone. They could have said, well, this was a discretionary program and they don't want to continue with it, and so they can shut it down because it's within their discretion. Or it could have taken the tack that it did, which is that, of course, any discretionary program can be started or shut down, but there are rules of the game to do so, and these rules include basics such as notice and comment or detailed memoranda, series of hearings, but public exchanges of information where the administration could have gone forward and done all that was required. The Supreme Court now gives them the blueprint of what they have to do. They have to do A, B, and C, and the administration will, in all likelihood, do A, B, and C. So we're now, unlike the Supreme Court census case, which had a built-in, baked-in timeline to it because of deadlines, this one doesn't. And so it could be dragged out for a long time. And as we come up on the election cycle, it's not quite clear what the timing is going to be. My guess is the administration will run pretty quickly with this. But it is a victory for the dreamers, almost 800,000 of them. But at the end of the day, all they get is extra time because the sword of Damocles is still hanging over them. At its very best, DACA did not provide a pathway for legalization or for citizenship. They still don't have that pathway, and it's going to require congressional action and presidential support in order to have either a DREAM Act, which has been passed by the House and is awaiting hearings and acknowledgement by the Senate, and the other option would be comprehensive immigration reform. When the issue of the DREAM Act came up in Congress before, the Bush administration said that they didn't want a DREAM Act to be passed because it would get in the way of comprehensive immigration reform. I want to take people back to that time and say that passing the DREAM Act would be the first step toward comprehensive immigration reform. This has always been considered the low-hanging fruit. Not only are there many very capable and eligible students for this program, it's been an unalloyed success. I'll be glad to answer questions on what those metrics of success are, but by any stretch of imagination, it has been successful. What is needed, however, now is for formalization of this so that it doesn't depend upon the whims of an administration that was unwilling to take the extra steps to shut down the program. I'll end there because I know all of you are bursting with questions, and Jeff and I will be.
Yeah, let me just say one more thing. Let me just make a couple highlight points from the decision, if I may. And thank you, Michael, for that recitation. I think that's a really great way to put it or frame the decision. I would say a few things. Number one, the court in the plurality decision was very clear that DHS, Department of Homeland Security, acted arbitrarily and capriciously. They used the word arbitrarily and capricious. And so what this means is that they violated the APA, the Administrative Procedure Act. What they said was that Acting Secretary Duke, in her memorandum, failed to give a reasoned analysis.
It was actually Nielsen.
Well, it was Duke. It was Duke. If you look in the decision, they reference Duke because Duke was the acting secretary. And then what they say is they failed to consider the quote unquote legitimate reliance that was on the part of the DACA recipients. And I noticed, I have a blog out which I discussed the reliance issue. It's a short piece that I did after the oral argument. And one of my observations was that I didn't think reliance was discussed enough in the oral argument or appreciated enough by the justices. Clearly, the reliance interest of the DACA recipients was considered and found to be an important factor by the Supreme Court. The last thing that I'll say is that look at what the government was arguing here. If you really think about it, put it in context. The government was arguing that they had unfettered discretion. They were taking the unreasonable position that the Supreme Court had no ability to even review the DACA rescission. So I think this is important, and we need to, in addition to what Professor Olivas is saying in terms of DACA, but we need to look at this also as a judicial review and reviewability decision, because the Supreme Court is issuing a resounding rejection of the administration's position here and saying, no, the Supreme Court does have the ability to review decisions, even if they're within the discretion of the administration. So I want to make that point loud and clear. And if you want to discuss further about the APA, I see there's some questions in the, I'll turn it back to Michael if there's some questions in the.
You're controlling the questions, Jeff, so why don't you read them aloud? Okay,
there's a question in the chat. Thank you, Michael. There's a question, take us through the APA and how is that going to be applied here?
Well, the APA is a long-time law that makes it clear that any agency action has to be taken with full consideration of the facts and the law. That normally includes notice and comment, where the administration will say, we're going to do X, Y, and Z, and here's why we're going to do it. And you post that in the Federal Register with a period of time to take in comments. So when the administration wants to enact a new program or to undo a regulation or something like that, they will post it, and then they will print in the Federal Register all the hundreds, sometimes thousands of responses. In my life, I counted that I have probably responded to over 70, in my career, over 70 of these, sometimes for, sometimes against, because I wanted my voice on the record. And that forms the public record for the administration and implementation of any action by a federal agency. There are other ways to do it in addition. Usually in addition, you can hold a series of hearings on the record. I've also testified in front of those. You can invite additional comments. You can write people. I mean, there's all ways to make your voice known, and sometimes there's almost always a rancher in Montana who's writing in about the effect of introducing wolves into his pastures and so forth. And it's a check on power so that the people and interested parties have an opportunity to make their opinions known. It's actually quite routine, although by my count, over 30 instances of violations of the APA have been charged by people with this administration, which has simply, especially in the immigration area, has simply tossed the playbook out in asylum and so forth. I was involved in a recent case where the Census Bureau said that they wanted to ask questions about race, which were unprecedented, and they wanted to do so under a certain time period because they had to go to print. And they said they were doing this because they thought it would construct a better case. Well, it turns out that the expert witness for the administration had died and left his records to his daughter, who was not in favor of this. And so she released them. And it became clear that they were doing this as a voter suppression matter, trying to identify people who were out of status. This is in order to try and cut down on the numbers of undocumented people being identified for a variety of reasons, including allocation of money and so forth. And so they didn't change their tune. They said, no, that's not why, even though it was clear from the exchange of emails, that was the only reason they had done this, that plus nativism. Well, here, a series of acting secretaries have said, we think that this program by President Obama was illegal and that he didn't follow through and that he tried to arrogate the power of Congress to himself. And so they wanted to shut it down without going through all these steps that are required, which would have taken 6 to 8 months in the normal time, given the complications. They kept saying it was illegal. Well, it's not their determination to determine what is legal. That would, of course, be a court or judicial opinion. And now we have it, that they did so with power they could have used, but they did so without explaining themselves, and they didn't take into account what turned out to be detrimental reliance upon this for the 800,000 DACA members who were affected by this. Now, let me just very briefly remind you that if you have DACA, it means that your deportation clock is stopped because you have lawful presence for the time being. That is, the burden then becomes upon the United States to find you deportable. So it stops their deportation clock. Number two, it gave them what's called EAD, or EA, employment authorization, which meant they could work. This, of course, is the most important thing for some of these kids. It also gave them Social Security numbers and ability to participate in that important program. It also allowed them to leave the country and return with what's called advanced parole. So if their grandmother in Guadalajara died, they could go back and notify they wanted to return to the United States and then come back in with an agreement that would be recognized that they were eligible to come back in, even though they didn't have legal status. So they didn't have legal status, but they have legal presence. And that's an important distinction. But I don't want to dwell on the benefits because those are pretty well known. But what they did do when they tried to stop this program was not to admit any new people. So I say this is like the Civil War's Widows Fund, where you start out with 10,000 and then every day you lose some until it's exhausted. So there's been no new DACA members. They're eligible to reapply every 2 years, and I urge all of these students to keep doing so as long as they're eligible. And even with today's opinion, now the administration has the roadmap for exactly what it is they have to do. Of course, they knew what they had to do, but now they've got to actually do it if they want to shut this program down. And if they do so, they'll have to do A, B, and C. And then at the end of the day, they'll make a decision. And lo and behold, after taking in all this information, they're going to decide that they don't want to continue the program. And they're going to give a decent reason instead of the nonsense reasons that were given and that were doubled down on. This case is several layers beforehand, and it was clear that at several points, the administration could have acted properly, especially once they knew they were being called out on it. Well, it turned out that a majority of the Supreme Court did call them out on it, as they had done with the census case, and said, this doesn't smell right. This is not correct. It doesn't follow the basic rules of the game. And if you want to play, you've got to follow the rules. So that's what the APA means.
I have a
here.
couple. I have a couple further remarks on APA. I think sometimes you'll see, and Michael alluded to this, Professor Olivas, that sometimes the government tries to shortcut or short circuit the APA procedures. For example, sometimes they'll try to do an interim final rule. I don't think they're going to be able to do that now. I think they're going to have to, as Professor Olivas said, they're going to have to follow all the steps and all the procedures, which means, you know, notice of proposed rulemaking, notice and comment periods, proposal with respect to the Federal Register, and they're going to have to go through all those steps. And I'm sure you're going to ask, well, how long will that take? Professor Olivas, you may disagree. I think it's going to take at least 6 months, maybe 8 months, maybe more.
No, I certainly agree, especially because there's no timeline built in. Remember the Census Bureau, where they found exactly the same misrepresentations and failure to follow the rules. There were some built-in lines because they had to print the census. And so it had time certain built into it. There's no timeline baked into this. This has been going on now for a number of years. And but it doesn't change the basic landscape that with the new students will be able to be added, or that it can be changed from 2 years to 3 years and so forth. We're back to the basic rules here. And what it means is any important complex program such as this, trying either to start or to end a comprehensive program, is simply going to have to give its reasons for doing so. We should expect no less than that from our government.
Do we want to open it up for any questions? I know that there are a lot more people than, I think Noman is the only one who asked questions. Anybody else want to ask any particular
Tell them what
questions?
they have to do to ask a question.
Well, they have to
Send
just,
you a question.
well, they can send me a question on the comments. Does the ruling say if the administration has to accept new applications or just renewals?
Yeah, well, that wasn't at issue here. This was a fight for its life and its survival. They have not revisited this, although it's now being sent back to DHS for its own actions, and I'm assuming they will stick with their guns on that. I don't expect them to open this up, and it wasn't before the court to order them to do that. The sole question is whether or not they had the discretion to close this program without following the APA, and the answer to that is a resounding no. And was there a trust relationship so that the DACA recipients, in good faith, gave information? They gave their biometrics, so all their DNA and eye pictures and so forth are now held by the government. And a lot of these kids, of course, live with their parents, and so there's a lot of people at risk here. All this does is buy new time. I think it's, even I, a hardcore supporter of DACA and the DREAM Act, would say that the administration, if they have the authority to enact a program, they have the authority to dismantle that program. But there are rules to do that, and they were not followed here. And as a result, nearly 750,000 DACA recipients who've kept their part of the bargain were found to be at risk because the administration simply determined that the program was illegal and they didn't want it.
Yeah, there's another question from someone about Sotomayor's, Justice Sotomayor's dissent, arguing that respondents' claims should be remanded. I think what they're referring to is equal protection, and the fact that there was animus that was in the Sotomayor.
Yeah, they could have gone that way, and you know, I believe me, I wish that Justice Sotomayor had been the author of this opinion, because there's a lot of other nuances in here that I'm not going to go into that would have pinned this down and would not have changed the result here. I think the fact that the Chief Justice did this was important. Her opinion matters, but it doesn't matter on the merits of the actual case.
Yeah.
And I think you can, even Justice Thomas, who's against this, says that you got to follow the APA. So he sort of gives up the ghost there. I think when it's all written and analyzed, there will probably be another 2 or 3 of the dissents that actually do ratify the points that Jeff was making about APA, which is so basic. I mean, it's taught in first-year classes, and I just can't imagine that this administration continues to litigate these important cases with everybody looking at them and with a very divided country and complex issues, and they don't follow the rules. I think that the president, the administration, simply hoped that their court would blink and let them do it, and that didn't happen. So the rule of law has very importantly been reestablished here and affirmed for purposes of these kind of complex decision makings that occur across a variety of domains on a daily basis.
I want to add something to Professor Olivas when you were talking about the issue that we were talking about in terms of adding new DACA recipients. I do want to make clear, though, that the Supreme Court vacated the decision on the part of the administration to rescind. So because it's been vacated, it leaves open the possibility, right? I mean, it does leave open the possibility for
the possibility was there
for new people.
Under either scenario, they could have done so. But I think by remanding it to DHS, they leave it to them. And I would be astounded, and we'll buy drinks for everybody. I'll invite you to Santa Fe and buy you green chili dinners if they are going to open it up. They're going to drag their heels. They're going to try and crab this as much as possible. They're going to try and discourage these students who have relied upon this. I do not see them, even though it's within their power, but it's always been within their power to do so. No one said they had to shut it down and render it illegal and cut off the new ones and do away with President Obama's second wave, which said that it could be 3 years instead of 2, and it also doesn't bring back DAPA, which was the program that was administered in the second wave, saying that undocumented parents who had citizen children also could have some benefits here. Those are all, as far as I'm concerned, they've always been on the table, but I just cannot imagine this administration saying that even registered DACA students had no rights. I can't imagine them all of a sudden giving this whole new infusion of extra benefits. They certainly could do it, but I don't anticipate that occurring.
I want to agree. I do agree, but I do want to just say with a caveat that there may be further litigation. So in other words, if this is remanded, which it is going to be remanded, and it's been vacated by the Supreme Court of the United States, then if the government does not open it up to the original 2012 DACA parameters, then I think there's room for further litigation.
Well, but you have to remember that US v. Texas is still lurking out there. A case that was unresolved that Judge Hanen from the Southern District of Texas enjoined virtually all of this, and it had gone to the Supreme Court after the Fifth Circuit had on a split decision affirmed him, and it was 4-4 because they were freezing out Justice Scalia's replacement, and so it ended up in a 4-4 tie before. And so that upheld Judge Hanen, but he stepped back and said, this egg has already been cracked and scrambled, and I don't want to try and assert jurisdiction. It will be resolved by the Supreme Court. Now, I am delighted that on this remand, which will affect the civil procedure of that particular case, which is just sitting there dormant for the time being, it will breathe new life into that. And the issue may very well be by the parties and the interveners as to what they could do, what's within their authority to do. But I frankly do not expect a whole new, in the short time, under complex circumstances with an election looming and uncertainty now that's going to have to be digested with this very complex, in some cases, mixed opinion that that whole new font of rights and benefits will spring from it. That could happen, but I would not take that bet.
I think it could happen. Any other questions? I don't have anything else on.
We're so authoritative. We're answering all their questions.
To follow up, does the ruling require the administration to issue renewals? For how long? So
well, the renewals were already baked in,
right,
and those will continue until there's a final resolution of this case. So that means 2 years at a clip. And I've encouraged in virtually every communication I've ever had with these dreamer groups, whom I adore. I think that they should all apply as quickly as they can. Make sure that they either pay the fees for it, or go to one of the community groups that has made fees available for these students. Make sure that you make no material misrepresentations, that you stay in school, that you don't leave the country and try and come back without permission, that you now that everybody has backed your play and found your situation to be important and deserving of some security. Now just make sure that you continue to do what you're supposed to do, that you, if you move, that you make sure you alert them and so forth. Don't give them any reason to yank or not be able to find you, etc. This kind of thing can happen, especially when the economic situation is just so dire. I might add that just yesterday, another major employer was required to follow DACA and employ people who are otherwise eligible. I mean, this has spun off dozens of cases where employers say, well, you don't have an employment authorization that's permanent. Well, employment authorization is employment authorization is employment authorization. So employers, do your part as well. If you have a DACA applicant who's otherwise eligible and you want to hire, they have the ability to work in the United States until they don't. And so for some kids, that's already been going on 10 years of work that was supposed to be temporary.
Let me just add to that. That's an excellent point. I would just add to that just yesterday a decision came out. A settlement came out with respect to unfair or discriminatory lending practices and DACA recipients. And that settlement was a $19.6 million settlement. Some people on the Zoom call should, if you guys have not seen this, you should report about it. It was a case involving Wells Fargo and DACA recipients. And that should get a lot of press and should be discussed, because again, it follows what Professor Olivas is saying, that people with DACA have rights. People with DACA should not be discriminated upon because of their status as a DACA recipient, lawful presence. And if they are being discriminated, then they have the ability to get redress and file these lawsuits. So they've been successful. And again, it just was released yesterday, June 17th, was a settlement with Wells Fargo and a variety of different plaintiff groups with respect to unfair discriminatory lending practices and DACA recipients. Can you share what district that settlement was? I believe it was California, Central District of California.
Yeah.
And we have the press release we can email to you. Just to clarify, hopping in here late, somebody wrote, it's likely they will accept no new applicants, but renewals are open for now. That's correct. I would say Professor Olivas said that they will not accept new applicants. I said, in addition to that if they don't, that will lead to further litigation, because again, what the Supreme Court did here today was vacate the unreasonable, arbitrary, and capricious decision on the part of the administration to rescind. So that's been vacated. So if the government does not uphold the 2012 policy from Obama to give people deferred action for childhood arrivals, then there will be further litigation.
Yeah, and there still is litigation that has already been enjoined and has been fully developed. On that particular point, I don't want to second guess what the administration is going to do. But even here they've got a rule. They could have an interim rule where they say we don't want to do this, and then not do it that whole period of time, and that would be legal within the parameters of this particular bill, this particular decision. But it is fluid, but I do not expect the administration is going to become woke on this or say, hey, DACA lives matter. I don't anticipate any opening up of that with new benefits and opportunities. I do think that it will be enjoined, but that would set in motion a whole new series of deadlines and so forth. And what these students have in favor right now is time. All this has done is buy them some time, because the administration is unlikely to be convinced by the thousands of people like me who write. And if they were willing to misrepresent and engage in mendacity to this point, I don't expect any new progressive features saying, oh, well, we were wrong and we were convinced by these 5 justices. I don't see that this is not going to be a Damascus moment for them where they're knocked off their horse and from Saul they become Paul. I don't see that happening. It is technically possible for that to happen, and I would love for that to happen, but I just don't see it. Not with Stephen Miller and the DHS folks who've already come to this decision and who've doubled down on it. They had, as I said before, they had any number of opportunities to correct themselves mid-course and probably to have won the case, but they chose not to do it, and that's what disregarding the rule of law means, even in today's jurisprudence.
Next question about how many people are affected in Texas, how many people are affected in Houston, and why don't they just become citizens? So we know there's 800,000 nationwide, tens of thousands in Texas, right?
Yeah. Believe me, if there's anybody on this call who doesn't think these kids who are very savvy would have used any opportunity, any legal opportunity to become permanent residents and then ultimately citizens, why wouldn't they have done so? It's not like they're sitting around saying, well, we really like DACA. We'd rather be here with a sword over our head than not to have opportunities. The reason they haven't is because of the failure of immigration reform. The Immigration Reform and Control Act, for its purposes of allowing people opportunities to become permanent residents, no longer has any force. There's one small category. If you've been in the United States unlawfully since 1972, then you can have what's called registry. So some grandmothers along the Brownsville border might very well be eligible, but none of these kids were even born then, and they don't get to take advantage of that. There are no opportunities for them to convert themselves into lawful permanent residents.
Well, I would say that in my clinic, I'm the director of the immigration clinic, and I also have been practicing for 20 years. So we do see people on occasion that have DACA, right? They have lawful presence under DACA, and then they don't know that they have other modalities or other avenues for relief. And I know Professor Olivas will agree with me that if somebody has, for example, a lawful entry, and then something else happens in terms of their life events, and they're able to have a bona fide and valid legitimate marriage to a U.S. citizen or something like that, they may have possibilities. Not to say it's a guarantee that they'll be able to get adjustment of status and eventually apply for citizenship, but a lot of these people need to go to competent counsel and get a full screening with respect to their other possible modes of relief.
Yes, that's true of any person who's an intending immigrant, but may or may not have the opportunities. It's not unique to DACA in that regard. I once had a client who had been in the United States and was a professor, and he wanted to become instead of a permanent resident, he wanted to become a citizen. And it turned out he was actually born in the United States. His mother had born him out of wedlock, and he had not known that. And so we went to LA and found his little footprint there, and there it was, the key to his future. And it turned out he was a citizen, but because of unique personal circumstances, in this case, maternal embarrassment about the situation, he didn't know they had that opportunity. And so he's now, he was actually a birthright citizen, born in the United States.
You know, the point that I always make in these things, and I've been an expert for DACA litigation cases, for one DACA litigation case that I just mentioned earlier. What I made the point I made is very similar to the point you're making, which is people in the public have a misunderstanding, I think, that there's illegal versus legal, and that those two are black and white. In other words, there's no possibility of anybody making the transition from undocumented to documented. And that's a mistake, because obviously we know as immigration practitioners and scholars that it's actually, in some cases, not all, but in some cases, there are legitimate opportunities for people who are undocumented, who may have been undocumented for decades. They may have been living here in the shadows, but in some cases, and in fact, many cases, there's a possibility for them to obtain relief and to change their status. And so this idea, this sort of misconception in the public consciousness that there's just this body of quote unquote illegals out there that are doing nefarious things is just so entrenched, and I would say so misguided, because it fails to understand the nuance. And the nuance really is that a large proportion of those people, the 11 million, 12 million people that are undocumented, they may have relief. And if they come out of the shadows, if they're given a chance, for example, with DACA, and to stay here lawfully and to get legal help, a certain percentage of them will be able to stay eventually.
Yes, what that, as accurate as that is, and I've had the same experience in representing or serving as an expert witness, the truth is that DACA was always seen as an interim measure that provided some generous benefits, but it also precluded these kids from any eligibility for Title IV, like Pell Grants, student loans, etc. And it also did not provide in and of itself, like if you have DACA for 6 years, then you're eligible. It didn't have that kind of automatic pathway.
Correct.
That would have exceeded the law, and it was a misreading, and I think a prejudice on the part of a nativist administration that simply assumed that these kids were otherwise ineligible, and they were all scam artists, and that they were all undeserving, and that's just simply not true. As best I can tell, and I follow this stuff as carefully as anybody, there have been fewer than 50 of that 750,000 who have been removed for failure to reconstitute themselves, to reapply. Many of them didn't have the money. Many of them got hinky. Some of them had what are called serious misdemeanors, DWIs, and so forth. These kids are more law-abiding with reason than U.S. citizens are. Let me just say, they're admirable, and they're now doctors and lawyers, and teachers, healthcare workers.
Yeah.
There are a number of states, such as New Mexico and California, that have passed laws for even the undocumented to become licensed with certain occupations. Florida has passed a law that says if you have DACA, you can become a lawyer. And any number of states have do not actually have immigration requirements, because they never anticipated there would be this huge cohort of truly talented students who got there on their merits and without any benefits, financial benefits that came with it, like financial aid, and that they would present credentials that were as good as anybody else's. And so this is a truly spectacular success story, and it deserves telling in its own terms, not just as the objects of an administration that talked out of both sides of its mouth, and then turned out to be the gang that couldn't shoot straight. They couldn't close the case because they didn't follow the rules.
And I would, and to pick up on, or just to summarize, I think what we're both saying is the necessity for comprehensive immigration reform still exists. In other words, this buys us a little bit of time, but reform on the part of the legislature is still a necessity. And I think that Professor Olivas and I both agree wholeheartedly.
And I would say, I would even accept a half loaf right now, the DREAM Act, which wouldn't help those kids with their parents, but it would give them a pathway. That would help. And I just disagree with the various people who say, if we do that, we'll never have comprehensive immigration reform. Well, we don't have comprehensive immigration reform.
Right.
It's been sitting there on the table since that famous liberal President Reagan signed it in 1986. We have done nothing since that time.
Amnesty.
Take back provisions.
What is the significance of the ruling keeping DACA in place in the midst of COVID-19 pandemic? So this is a question about the pandemic, and I mean, I'll just say that I think that the question contains an erroneous or implicit assumption that immigrants are somehow, you know, a force, you know, for bad in the country, or somehow the source of disease or something like that. So I would reject wholeheartedly the presumption of the question. But go ahead, Professor Olivas.
Well, I would just say I took that in a slightly different way. I didn't think that was a snarky question. As to employment, it certainly matters because these kids were the most recent hired and therefore probably let go. If they can't make it financially, it's not like they can go to the bank and take out loans or, you know, use some of the money that their father, a big developer, gave them $400 million in their lifetime. I don't see it can affect them, and they in many states don't have access to the ACA either. So
right.
And students as a general rule are underinsured, so that I do think that they're more vulnerable. I'd put it that way. Yeah. I didn't see that question as, are they trying to get over on us, or are they caravans of bad hombres, you know, bringing germs and so forth?
Well, she clarified, and she said she was referring to Dreamers as essential workers. And I think that's an excellent point. So to the extent that this helps people with DACA stay in the country and be here and serve our communities and be essential workers and be first responders, which many of them are, this is going to be seen as a positive in the fight against COVID-19. So I think that's an excellent point.
Yes. And in fact, there was extra testimony given about 6 weeks ago, showing that well over 20,000 was it, of these DACA members are involved in healthcare now, including licensed as doctors, nurses, technicians, and the like. But them being DACA-mented has no peculiar bearing upon COVID or so, except that they are rendered more like many other populations, especially racial and ethnic ones, and poor people, that they are more vulnerable in that regard because they have fewer resources and access to other benefits.
Okay, I don't see any further questions.
Jeff, I do want to point out that as of last Sunday, available in fine bookstores everywhere, soon to be a major motion picture starring Jimmy Smits as me, is my book, Perchance to Dream, which is the first book that sets out the legal and political history of DACA and the DREAM Act. And I started the book as a birth announcement. In 1981, when Senator Kennedy and Senator Orrin Hatch introduced the first DREAM Act, I took bets that I've been paying off ever since, that would enact the DREAM Act because it included both ends of the spectrum. In the years past, that's, by the way, the year I graduated from law school. Here I am retired now, almost 40 years later, and we still don't have a DREAM Act. So my book is a dirge to this, but I've never given up because I do think that these students, these DACA students, and ones who would be DACA had they been allowed to apply, are models for us. This is a program that worked. It was self-sustaining. It paid for its own way, and these students have been active members of our society, marrying into our families, holding excellent jobs, and they are not scoff laws. They are law-abiding, and they are our students. In 1981, Plyler,
Yeah.
1982,
Yeah.
said that states such as Texas could not remove these kids from school or charge them tuition. This is what happens when you have the high water mark of immigrant rights, and then it turns out that Doe goes to college, and they go to school in overwhelming numbers at the tops of their classes and at the top of their games, and we want them. We don't want to return them after having invested in them to some other country to let them take the advantage. We want to incorporate them into the citizens that they will become. And so this is a much larger story, is a larger part of narrative that is actually favorable and optimistic. And I want to thank my colleague, Professor Jeff Hoffman, as well as the University of Houston Law Center media staff for doing this. If people have follow-up questions, they're welcome to look us up and send emails. I see a list of about 20 other emails I've already gotten and texts and so forth. This is a good day, but it's only a temporary stop on the road to Damascus, because we still have to resolve this. And who wants to deport 800,000 accomplished people? That would be simply giving up, and that's not the better angels of our nation. Jeff, did you have anything that you wanted to say?
Yeah, I'll just conclude by saying one of the questions, I think the last question is about whether it's legitimate to have a reason to attempt to end DACA. But I want to point out that the actual DACA program that was rolled out in 2012 was legitimate. And it was legitimate because, and we've all, looked at the research and seen the authorities that support this. It was legitimate because there's a long history in this country of prosecutorial discretion. So I want to make that clear that DACA is legitimate. It was rolled out lawfully. And so if there's any reason to rescind it, obviously they're going to have to, make that argument that it wasn't legitimate at its inception, and they're going to try to do that. Again, I don't think that the answer is going to be forthcoming before the election. I think the answer is going to have to happen after the election, and I think it's going to be a matter for the legislature and not the courts.
Yes, I would like to end on that note as well, that the legislature has always had the opportunity to act on this, irrespective of this particular program or this particular case. After all, it's going on eight plus years that we've been in this sort of Damocles situation that never really had a good end game to it. The good end game to it is the DREAM Act, which has been passed by the House and which is in front of the Senate and has never even held a hearing on it, or ultimately comprehensive immigration reform. And I think that voters will signal their preference here. And I want to just acknowledge that we have been the fortunate beneficiaries of these kids who had all these built-in headwinds, whose parents sacrificed to bring them here, whose families have lived in the shadows and done work that United States citizens simply don't want to do. And these kids have transcended and followed the American dream. It's a uniquely American dream where your parents can come here without status and you can end up a doctor helping others. That is the American dream, and all of us in our hearts truly believe in the efficacy of that dream. Thank you all very much.
Thank you very much. We appreciate the opportunity to answer your questions. Thank you.
Thank you all for joining us. If you have any questions, feel free to email us at uhlawcom@uh.edu. Damali, did you have one more question?
No, I was just saying thank you. And are you guys going to email the press release regarding the Wells Fargo decision from yesterday?
I'll be happy to do so. I have it. I was the expert, or one of the experts, for the plaintiffs in that case. So I'll be happy to do that, and we'll email that to you. If you could email me so I have your email address, or email Carrie, and she'll forward it to me. Thank you.
Perfect. Thank you.